everyone, my name is Vaishnavi Parate. I am a law student and today we are going to discuss and learn about what are the bailable and non-bailable offences. Let's start from the introduction. The Indian Penal Code 1860 classifies offences into compoundable, non-compoundable, bailable and non-bailable offences. Now let's discuss bailable and non-bailable offences. Bailable offences are those offences where setting free an individual from prison confinement is a matter of right. In simple terms, it means that bail can be taken as a right without any prohibition, whereas non-bailable offences are offences where bail is a matter of discretion. Now let's discuss about what is a bailable offence. The definition of bailable offences under Section 2, Clause A of the Code of Criminal Procedure 1973 states that bailable offences are those offences which are shown as bailable in the first schedule of the code. The bailable offences can be termed as offences where bail is a matter of right because they are of no grave nature in respect to the seriousness, and that is why generally they are punishable for 3 years or below or with a fine. In the case of bailable offences, bail can be given as a matter of right and it can be taken from the police officer in whose custody the accused is or through the court of law. Now let's see what is non-bailable offence. Non-bailable offences are not defined anywhere in the code, but for general comprehension, these offences can be termed as heinous in nature. These offences are of grave seriousness in nature, and this is why they are termed non-bailable. The reason for categorizing these offences as non-bailable is the safety of the common public in society. It would be difficult and unsafe for a common man to live in if there were offenders roaming free on the streets. Now let's see some important sections which talks about bailable offences and non-bailable offences. Section 2, Clause A of the Code of Criminal Procedure 1973 defines bailable offences. Section 436 of the Criminal Procedure Code 1973 deals with bail in cases of bailable offence. Section 437 of the Criminal Procedure Code talks about when bail may be taken in case of non-bailable offence and states the provision in respect of regular bail in criminal cases. Now let's differentiate between bailable and non-bailable offences. In bailable offences, the gravity of the offence is lower as compared to non-bailable offences. In non-bailable offences, the gravity of the offence is higher. In bailable offences, generally, the quantum of sentence is below or up to 3 years. Sentences are higher in case of non-bailable offences as they are punishable with death, imprisonment for life, or imprisonment which may exceed 3 years or 7 years. In bailable offences, bail can be granted as a matter of right. In non-bailable offences, bail is not a matter of right, but rather it is a matter of the discretion of the court of law. In case of bailable offences, either the police officer or the court can grant bail. In the case of non-bailable offences, mostly the accused get bail through a court of law. Now let's see some important case laws for better understanding of bailable offences and non-bailable offences. In Rasiklal versus Kishore Khanchand Wadhwani 2009, the Honorable Supreme Court held that the right to claim bail granted by Section 436 in a bailable offence is an absolute and indefeasible right. In bailable offences, there is no question of discretion in granting bail as the words of Section 436 are imperative. In case of non-bailable offence, bail is entirely dependent on the discretion of the court of law. The same was held in Pramod Kumar Maglik versus Sarna Rani 1989, that the term may denotes the discretion of the court.